This is The Law Show on CL 650. Now back to the show.
Nice to have you with us. Our guests in studio are Joel Murphy and Angela Price-Stevens from Murphy Batista, personal injury lawyers in Vancouver at 650 West Georgia Street and online at murphybatista.com. I should give you a little help here. Murphy's pretty easy. Batista is BATTISTA.com. Lots of information there, including contacts for both of our guests, Angela and Joe Murphy. We're talking about going to ICBC after being involved, as many of us do, in some kind of, fender bender. But not just a situation in which the vehicles have been damaged. That's pretty easy to deal with. There's a little bit of paint, there's a hammering out of a dent or two, life goes on. Nobody's hurt. Everybody walks away. Well, those would still be the majority of accidents, I guess, on an annual basis recorded by ICBC, Joe. Just two vehicles clang and repairs needed, off you go. Next, very inconsequential.
Sterling, my guess would be 75% of accidents don't result in injuries, but that's just a guess. Mm-hmm. It's the majority.
Okay.
I would also just note to that when you're talking about ICBC statistics, what collisions result in injuries, they are going to be skewed. They are inevitably going to be skewed. And I say this because ICBC have this notional, it's a fiction, called low velocity impact claims, LVI claims. And this immediately comes to mind because I've just taken on a client who had a nasty rear end collision, and it was that accident that brought him to me. And then as I'm getting to know him, I'm getting to know his history, he said, oh yes, well I had an accident last year too. And I was like, hang on a minute, you didn't mention this.
Right.
And he said, oh, but ICBC said it was something like LV, and I said, you mean LVI? He goes, oh yes, they said to me that, oh, this is LVI, there are no injuries, so we cannot pay you for your sore neck. And it's a nonsense, because
this was ICBC's actual position?
Yes.
Was this position taken by a doctor on behalf of ICBC?
Well, this was the adjuster apparently telling my new client that because there was next to no damage to his vehicle, and my new client said, oh yeah, there was hardly a touch on it. There was a scratch because there was the hitch, the tow hitch took the brunt of it. And he said, I've had this sore neck for all this time, but I'm getting on with life. But my client had simply accepted that, ICBC had designated it a low velocity impact claim, and therefore we cannot pay out on it. And that's kind of drives me crazy, because there's actually no such thing. This is just terminology that the corporation has just made up
to discourage claims. To discourage,
yes. And there's plenty of judgments out there that say that this is a legal fiction. There's no legal basis for this. It's not about the damage to the vehicle. It's about the damage to the individual in the vehicle.
So if someone listening has been recently dealing with ICBC on the basis of a collision of some kind, and some ICBC person has told you that this is a low velocity impact event,
yes,
and therefore not considered by us to be serious enough to warrant injury or certainly any damages awarded. Mm-hmm. And if that has happened to you, is this person from ICBC basically talking through his or her hat, Angela? They just making this up?
It is a nonsense. It is a legal nonsense. The courts recognize it's a legal nonsense, but it is a policy. Now, a corporation can come up with any policy they want.
Sure.
You can challenge the policy, but there's no medical or scientific basis to justify that policy. It is just simply something, and they'll often say LVI. They won't even say low velocity impact. They'll just blind the potential client or the potential claimant with pseudoscience. Exactly. This is an LVI. There was really no damage to the vehicle. I'm sorry, we can't pay you out. It is a nonsense.
Okay, so Joe, this all is again predicated on ICBC adopting this policy where they're not going to pay for these low velocity impact collisions. However, as you pointed out already on this program today, sometimes a low-velocity collision can result in serious injury that may take a sustained amount of time to even show itself. It may take months after what seemed to be a harmless little thing in the parking lot. All of a sudden you wake up one morning, you can barely move. And it happened, it's as a result of that accident in the parking lot a few months back. And if you signed something, how hooped are you the morning you wake up and you can't move?
Well, it's the risk. It doesn't mean you're automatically harmed, but there's the risk of it happening. Sterling, the other thing that ICBC does is they look at the vehicle. Usually it's a bumper. Someone's been rear-ended.
Yeah.
And most cars are designed not to be damaged in a rear-end collision. And there's some cars, and I know this from talking to an engineering friend, the old Toyota Tercel, you could hit it with a tank and it would look to be untouched.
Mm-hmm.
So the idea that the lack of any apparent damage means there really wasn't an impact just doesn't work. That's not the way the world works.
Right. It has nothing to do with automobile design in the new millennium, does it?
And I was involved in a case. It was a fellow on Vancouver Island, rear-ended, had neck and back problems. And the adjuster actually wrote to the family doctor and said, Dr. Smith, I'm enclosing photographs taken by the estimator. And as you'll see, there's no damage, and the estimator examined the vehicle, and there's no damage. So I really don't understand how you can say this man, your patient, was injured. And the doctor wrote back and said, thank you for your most interesting letter with the photographs. Period. Paragraph. If you want me to send the x-rays to your physical damage person who inspected and photographed the vehicle, maybe he can tell me why his bumper looks so good and his neck looks so bad. Mm-hmm. Yours truly.
Right.
And that really was it. I thought the letter was great. But it's not about the bumper. It's about your neck or your back or whatever.
Right. So the warning here, the takeaway, we always try to leave a few takeaways, and Angela, you've given us a couple already, but the takeaway from how to deal with ICBC, I get the feeling that rule number one should be, for goodness sake, don't sign anything. Is that a reasonable rule number one, Joe?
It is, Sterling, but for the person in the claim center saying, I'm not going to sign this, immediately creates suspicion with ICBC saying, okay, what are you trying to hide?
Right.
So it's really got to be handled carefully in order to avoid this person being immediately labeled maybe a crook.
Right, or maybe just deliberately being aggressive, obnoxious behavior, all this kind of stuff. So, Angela, what do you say? What's the dance you do at the claim center or at the ICBC office when they hand you the clipboard and say, we need you to sign on lines 3, 4, and 9? What do you do?
I think what you do ideally is to call and speak with a reputable lawyer before you go into the claim center.
Ah, good point. Okay.
And just
don't even show up until you've talked to a lawyer.
Absolutely.
Okay.
I mean, yes, you're under an obligation to do certain things, but very, very few. It's you sign the claim form. You don't need to sign any releases. The so-called statement you're obligated to give. The details are very, very brief. It just needs to say the date, the location, and the vehicles involved, and you confirm your name and your driver's license number. Anything else is extra for them.
And what is the legal limit for that basic statement of fact that you identify yourself, your vehicle, the location of the accident, and so on? How much time do you have after the accident has occurred to file even that modest bit of paperwork?
Well, it's not like a statute of limitation, because as you can imagine, if I'm seriously injured in an accident, what the heck am I going to do? Somebody's going to wake me from my unconscious state to say, you have to sign within the next number of days or hours.
Right.
So, of course, there has to be some leeway. 30 days.
Oh, okay.
But again, it's a reasonable period of time. So I would never suggest to somebody out there listening, take your time. You've got 30 days. Keep them hanging for 21 days. You've still got 7 to play with.
Right.
You need to be cooperative. You need to be seen to be cooperative, because to be seen to be anything else is really not going to act in your best favor.
Right.
So what you need to do is have a lawyer. I wouldn't say a lawyer on speed dial. That's so melodramatic, and that's not what I'm wanting to convey. But just have the presence of mind to say, okay, I'm going to have contact with ICBC. You know what? 9 times out of the 10, they are going to treat me well. But I'm just going to reduce my risks. I'm going to protect myself. I'm going to take that 5-10 minute phone call with a lawyer. I'm going to be given heads up. I'm going to be reminded of the advice I heard on the radio months ago, and I'm just going to make that phone call.
Right.
And then you go in within a reasonable period of time.
Right, and to be seen to be cooperative, Joe, to follow up on Angela's point, which is reinforcing yours, don't appear to be obnoxious and behaving wildly. That will prejudice them against you. So you need to say something to the effect of, well, I'm afraid I can't sign that right now. I really would like to consult with a lawyer before signing anything.
Sterling, what I suggest people do when they call me is when they go in to meet with the adjuster at the beginning of the meeting, say to the adjuster, I want you to understand I've spoken to a lawyer and I'm not intending to hire a lawyer. I'd like to deal with you directly, but I understand from speaking to the lawyer there's a number of forms that I don't need to sign.
Okay.
So if you deal with it first, then it's a very different scenario than the adjuster said, sign here, and you say, no, I won't.
Right. So you head them off at the pass.
Yeah.
And say, my legal advice to this point has been not to sign anything, and I'm going to take that advice.
Yep.
And that they can't reject that. They can't accuse you of anything other than, well, a smart person actually called a lawyer before coming to see us.
Yep.
And that would suggest also that you're serious. If you've had even a 5-minuter on the phone with someone like you, Angela, and you go and sit down opposite an ICBC adjuster, and that person, the first thing you say to that person is, I've had a discussion with a lawyer about this matter already, then the person at the ICBC end of things knows you're serious about what you're doing.
Yes, and I think the idea is that they would also mind their P's and Q's a little more and perhaps not push the signature for things that really are not required, because if you follow Joe's advice, you've already flagged, I'm really not going to sign anything that I don't need to.
Right.
And so if you've said that and then they still put file, they're just going to be far more wary about what they ask you to do.
The protocols of dealing with ICBC from two pros. I'll tell you, Joe Murphy and Angela Price-Stevens with us from MurphyBatista.com. Check them out while we take this break on The Law Show here on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.